let's now leave the case of Rylands and Fletcher and jump forward more than a century to another nuisance case. This one also concerns an escape of water from one party's land onto another. The way the courts approached this more modern case is a very good illustration of how the common law evolves over time. All common law begins with a solid precedent case, such as the Rylands case, but it then develops the principle of law that's been established to allow it to adapt to specific situations that happen afterwards. This flexibility is seen around the world as one of the great strengths of the English common law. The more modern case from 2003 is quite a straightforward one. The defendant in the case was what's known in England as a local authority. A local authority is an organisation that's part of local government. It has various responsibilities to the people who live in a particular part of the country. In our case, the local authority in the town of Stockport was responsible for the maintenance of one of the main underground water pipes in the town. The pipe in question carried water to many residential buildings in Stockport, including a high-rise block of apartments called Hollow End Towers. At some point, and no one is sure when, the water pipe leading to Hollow End Towers began to leak. In fact, it was a very serious leak that led to a vast amount of water seeping into the ground all around the pipe and quite far beyond. Even worse, the leak was deep underground and therefore not visible at all from the surface. So it wasn't until a huge amount of land was suddenly washed away that engineers from the local authority knew that their water pipe had been losing huge amounts of water for quite some time.
And this leads us to the claim in this case, because when the land washed away, it created an amazingly dangerous situation. There'd been a high-pressure gas main safely buried under the washed-away earth. A gas main is a pipe running underneath the streets of a town or city in order to distribute gas to its residents. Thanks to the leaking water pipe, a 27-metre section of the gas main was now exposed and unsupported, and could crack open at any moment. For the sake of public safety, it had to be checked out and buried again immediately, which was done at a cost of just over £93,000. The owners of the gas pipe figured that as the owners of the water pipe had allowed water to escape, that they were liable for the cost of carrying out the emergency gas repairs. After all, that was the legal principle that appeared to have been established in the Rylands case. But in this later case, the House of Lords ruled quite differently. After much debate among the judges, the highest court in the land at that time held that the local authority, which was responsible for the water pipe, had no liability at all to the gas company. What the House of Lords had done was to distinguish this case from the earlier one. They decided that the situation was sufficiently different for the same legal principle not to apply. Before we go any further, can you work out what their logic was in arriving at this decision? As lawyers, we have to ask ourselves, what is it that distinguishes this case from Rylands and Fletcher?